Thank you, Mr. Chairman. Could we take up 2806 instead of 2805?
Oh, that's a House bill number, so, but, all right, we've already got a motion and a second on this bill number. We can reconsider our actions. Leader Lambert to recognize.
Mr. Chairman, I make a motion to roll this bill one space.
All right, without objection, rolled one space. That brings us to item number 12, House Bill 2806 by Chairman Halsey. We got a motion? We got a motion and a second. Chairman Halsey, you're recognized on 2806, and I do show an amendment.
Yes, thank you. And the amendment is 014435.
That's what I show. Members, we have a motion and a second on the amendment. We got a motion. We have already adopted it, so it's already on there. So you're recognized on House Bill 2806 as amended.
Thank you, Chairman and Committee, for your indulgence and your patience with me. I appreciate it very much. We met before, as you know, and had several questions about this bill. There is a fear that securities, stocks, and bonds could be at risk for Tennessee people with the way the UCC code was rewritten in 1994. And this bill just is an attempt to protect Tennessee people that hold stocks and bonds and those types of securities. And that's the whole intent, is to protect their private property and their assets. And I today have to speak on this issue is Mr. Webb, who flew in here from Sweden just to be with you, and then Don Grandy, who flew in from North Dakota, which they're not just important people, but it shows you that I go for the quality folks, so I just want you to know that. But with your indulgence, if we could go out of session and hear what they have to say.
Absolutely. And without objection, we'll go out of session. And Mr. Grande and Webb, if y'all come up to the table. What we'll do is you'll have a seat there. We'll give you each 3 minutes. And once you give your name and title, we'll start the clock, and I'll let you know when your 3 minutes are up. So each of y'all have 3 minutes, so begin whenever you like.
Okay.
There should be a little face there with little dots. Yeah.
Okay.
Should be a red light.
There? Yes. Okay. Thank you for the opportunity to be here and speak with you. I'll begin by saying for 400 years, securities were personal property.
Could you identify yourself?
Oh, I'm sorry. My name is David Webb. I am a U.S. citizen. I am now looking at land in Tennessee, but that's another matter. So I'll begin by saying for 400 years, securities were personal property. Now, what that meant was if your account provider, your broker or your custodian became insolvent, you could take immediate return of your securities. That is no longer the case. Now, you no longer have property rights to securities. What you have is a newly created concept implemented through the Uniform Commercial Code of a security entitlement. This is not a direct property right. This is a contractual claim to your own property that is very weak in the event of insolvency. The other thing that's very important is that all securities are held in these massive pools, in pooled form at a higher level. They are not legally held at your broker or your custodian. They are held in massive pools at Depository Trust Corp. Now, the securities in these pools, because there's no specific identification of the investor to any security, they're not numbered, these pools are available for the securities industry to use without restriction for proprietary trading within the securities complex, within the industry. So what the situation is that people can be told that their securities are segregated at the broker level. It's just in the books and records of the broker. The subterfuge is that they are being used at a higher level in the system, where the secured creditors actually have ownership over the securities. Now, how do we know this? We know this irrefutably because the Deputy General Counsel of the New York Federal Reserve responded to a questionnaire from something called the EU Legal Certainty Group, so it was a formal legal response that explains the operation of the UCC. So this is not conjecture. It's from the highest source possible explaining how this works. And the Fed makes it clear that even segregated.
Mr. Webb, that's your 3 minutes. So we'll get we'll take Mr. Grande's, and then we'll take questions after he gets there. If it's just hang in there for me for 3 minutes. Mr. Grande, if you'll just identify yourself, and you'll have 3 minutes.
My name is Don Grandy. I am a private practice attorney and been working on this issue for quite a while with regard to the Uniform Commercial Code and more specifically to this issue. So in a nutshell, as Mr. Webb has talked about, with the 1994 Article 8 revision, they conjured a new type of property ownership or property right called a securities entitlement. The drafting committee defines a securities entitlement as a bundle of personal rights you hold against your broker. So if I hold rights against someone else, that's a contract. So it isn't a security in the sense that you thought you used to own something on paper. It's a contract, and any discussion to the contrary is false, and it's right there in the current UCC. So what this bill is targeted to do is remove two exceptions that give the secured creditors, banks, the largest banks, who have lent money to your broker or a custodian. There's two exceptions in your current statute that give those lenders priority to the investor's assets in an insolvency situation. So without the knowledge and consent of the investors of Tennessee, they could lose their securities entitlement, which is tied to the security they thought they bought, but that's a different issue. So they can lose their security entitlement to this bank, this creditor, to pay the debt of somebody else that the investor didn't even know about, didn't consent to. And so we just fundamentally think that's wrong. We think there's additional things that we need to look at, but first and foremost, we just want to restore some property rights to the people of Tennessee. And that's sort of the summation, so we'd be happy to answer any questions. I'm assuming there are some.
Thank you. And members, we got one on the list so far, and Representative Parkinson, you're recognized for Mr. Grande or Mr. Webb.
Thank you. Which is which again? I'm sorry. Grande? Webb? Okay, all right.
And Mr.
Okay.
Webb, just make sure
Right.
your red light's on again.
Yeah, thank you. And I'm not going to try to figure out who's from South Dakota or North Dakota and who's from Sweden. Take it for the team, but I do have a question, but after I finish the question, I do want you to finish your explaining everything. I think it's important for the people. I honestly think it's important for the people of the country to hear what you're saying, because it was all new to me and a shock to me. When I heard testimony the first time. Being a person that has invested in stocks, and to learn that the only thing I have is entitlement to what I spent money on. But what I want to know is this: at that higher level, where the pool of the properties are, what are they doing with those? What are they doing with that? Are they making money off of that? That's what I want to know.
Of the securities as collateral without restriction. So now this change in the UCC was in '94. It took a number of years for it to be implemented in all 50 states. Coincident with that, we saw the massive growth in the derivatives complex. Now, a derivative, it's kind of an intimidating word. What's a derivative? A derivative is just a contract written describing the behavior of something else. So derivative instruments always were contracts that would have had a weak standing in an insolvency. And what's been done here is to take what had been property, where people could have gotten it's called revindication, taken back their own securities. Those are now contractual claims, but the collateral is being used within the derivatives complex, and those were contracts, but the secured creditors there now have what's called super priority to those pooled assets. And it's only the biggest banks that have this super priority to take the assets out of these pools. And what we see from this Fed response to the legal certainty group is that the public only gets what's left in the pool after the secured creditors have taken from the pool. And it's very important for people to understand that this is not just individual investors. Think pension funds, investment funds. It includes the biggest, most sophisticated investors. They are told, they want to believe, and they want to believe they can tell their clients that their accounts are segregated. This Fed response makes it clear that that is not operational in the event of insolvency, which is exactly when you would need to have it. So how were they making money out of this? Well, the derivatives complex, by a little after 2000, had reached $110 trillion. That was about twice the size of global GDP. So this, by 2007, the financial crisis that was developing then, derivatives had reached 700 trillion. So it had gone from 100 to 700 trillion in 5 years. It's now estimated to be maybe 2 quadrillion, which is about 20 times the size of global GDP. Now, what made that possible was using these vast pools of the client assets as the collateral that is extended under these basically bets, these contracts. And so they're using someone else's collateral for their trades. And that's what has facilitated this massive global bubble that we're in. So what we're talking about here, have they made money through that? Yes, but it's about power and control. It is, and they're not going to tell you about this. They're the last people that are going to tell you about this because they are benefiting from using this resource of the public without restriction. And also, they have this term FOP, which means free of payment. They can use the collateral from these pools free of payment.
And y'all are welcome to go back and forth.
Okay. Thank you, Mr. Chair. I didn't even know quadrillion was actually a real word. You know, I thought it was something I made up when I was 7, but you know, but apparently it is. But you know, it's really. First of all, this is one of the most interesting conversations we've had in this committee to me. Secondly, you know, it's shameful that these things happen and the general public think that they're doing something, you know, to secure, a legacy for their families, and even at that level, they're still being used, in a herd mentality, so to speak, right, to be exploited without them even knowing that they're being exploited, and without even receiving benefit for the use of what is their property.
Yes.
And so, but I thank you for your testimony. You know, it's incredibly enlightening, and truly appreciate you being here, and you as well, sir.
Thank you.
Representative Bolzo, you're recognized.
Thank you, Mr. Chairman, and thank you, Mr. Webb and Mr. Grandy, for being here. I've got, questions that fall into three categories. One is to understand what the bill does. Number two, to understand what the concern is that has raised the need for the bill. And third, to try to understand whether the remedy actually addresses the concern. So first, with regard to the bill itself, is it accurate to say, Mr. Webb, that what the bill does is to reverse priority between the entitlement holder and the secured creditor in the event of the insolvency of the securities intermediary?
Yes, to make it clear that the investor has priority in the event of insolvency to the entitlement. Yes.
Okay. So that seems
As
like
clear as that. It's as simple as that. May I say more about
Sure.
that? Okay, so the way this was implemented in the UCC, there's a clear statement that the entitlement holders have priority over secured creditors. And for example, in South Dakota, this is what was read by the banking lobbyists, and they just stopped there. There's an exception. It then says except. So you then go to the next paragraph, and it says the same thing, that the entitlement holder has priority. And then there's another except. You have to go down 3 paragraphs, and then you see how it actually works. The exception is that if the creditor has control over the security, the creditor always has priority. Now, in an indirect holding system, it is easily done and always done for control to be achieved by other parties than the investor. This is an aspect, or this was made possible through dematerializing securities, going to an indirect holding system, a book entry system. When we had certificates, there was a bright line as to who had control. To give control to the broker, you had to formally sign that over. There had to be an agreement to sign it over. By dematerializing and holding the securities in these pools on a vast scale, it made it unclear who had control. So the industry developed the practice of using this resource without the knowledge of the public. And the amendment to the UCC in '94 was to make legal what they were already doing. So this approach, which Don has crafted, is simple and elegant. It is simply to strike the exceptions. So there's a full stop at saying that the entitlement holder has priority. Now, it's still an entitlement. We haven't gotten all the way back to property, but it at least restores clearly priority. Now, nothing should change at all. There's fear-mongering that if you make this change, it will be bad for business somehow. You really have to question that. Of course they don't want you to know about this or to address it. Nothing should change if you change this. It only comes into play in the event of large-scale insolvency, and then you absolutely want to have made this change. And frankly, the reverse, keeping it, is absolutely indefensible. Why should secured creditors have priority over the assets of the public, and when the public is not borrowing against that? This is what we have to understand. It's someone else that is encumbering that asset. So the public owning assets free and clear without debt they are vulnerable to this through this subterfuge.
And so if I understand the concern, it is that at some point in the future, one or more securities intermediaries may become insolvent. Is that right?
This is the major concern.
Okay. And
Yes.
an example of a securities intermediary would be a clearing broker-dealer?
This is one of the exceptions here as well that's very important. A clearing entity, the creditors of a clearing entity always have priority to the pooled client assets. So yes, the failure of a clearing entity will trigger this. Now, let me say further, what was done in the last financial crisis, an imperative was created to centrally clear all derivatives. So it used to be that derivative contracts were things like a farmer selling the crops forward at harvest time. And so the farmer was happy to sell at that price at that time. There was a party on the other side that wanted to buy the crop at that time. There was a real purpose to these contracts. They were bilateral. There was a party on both sides. The 2008 financial crisis was used to say, that's too risky, that you have a counterparty. We're going to centrally clear these things. Now, what that means is that your counterparty is the central clearing counterparty. And we have analyzed this. The central clearing counterparties are very thinly capitalized. DTC itself, which houses all securities for the U.S., it operates two of the major central clearing counterparties. The total capitalization is a little over $2 billion. That is nothing in the scheme of things. And DTCC itself is planning to start up and pre-fund a new central clearing counterparty when one of the existing ones fails. The industry is talking about the very real possibility that major central clearing counterparties will fail. They are preparing for it.
All right. But an example of a clearing broker-dealer would be UBS or Charles Schwab or Raymond James or Merrill Lynch.
A broker-dealer.
A broker-dealer.
But at this higher level, they are, let's say at the top of the food chain is DTCC and the central clearing counterparties in the derivatives complex. That's where these vast pools of collateral are being used.
So DTC has possession of the personal property.
Yes.
Is that correct? All right.
Yes.
And an investor doesn't have an agreement with DTC. An investor has an agreement with a clearing broker-dealer.
Yes.
And that account agreement likely contains a choice of law provision. Would that be true?
Yes.
And do you know typically what law's form is chosen in a choice of law provision in an account opening agreement?
Well, this is an important concept because the ancient principle, I've been through this in Europe as well, the ancient principle was that the law of the place of the property governed. So where the client was, where the property was governed. But in order to allow the transport of this collateral cross-border, that had to be subverted. And this is a fairly recent change, both in the U.S. and then later in Europe, quite recently in Europe. So it's now been done globally. And this place of law is a very important issue because the place of law can be set where the central clearing counterparty is, for example, or where the securities, the higher level pooling of securities, where that resides. So it is a crucial issue, and it's something addressed in this bill, is to make the place of law the state of Tennessee.
Is there language in the bill that does that?
Mr. Chairman, Representative, yes, there is language in the bill. I believe sections 1 and 4 would deal with jurisdiction. The current Article 8 breaks jurisdiction down into a couple of different steps. One deals with issuers, like that companies that issue stock. We don't deal with that in this bill. We don't have any issues with that. In that situation, the jurisdiction is in the issuer's jurisdiction, which makes sense because that's the entity they're organized under those state laws. The second one, and I'm 8103 or 8105, blanking a little bit on the section. The second jurisdiction provision deals with choice of law jurisdiction between a entitlement holder, which is an investor in normal people language. So between the investor and the securities intermediary, it's in the securities intermediary's domicile. The securities intermediary would be your broker, the broker's custodian, the custodian's custodian, up the chain. So this bill would say, if there is going to be a fight over my property as an investor, we're at least going to have the fight here in Tennessee.
Well, and let me ask you to follow up on that, Mr. Grandy. If a Tennessee investor has signed an account opening agreement that specifies that New York law is the law that governs the relationship, is there any effect that this amendment under Tennessee's version of Article 8 would have on that investor's relationship with his clearing broker-dealer?
I believe the answer is yes, and I can follow up with you on that. Right before this hearing, I was received an opinion that was just issued this week in New York court, because this is a state law we're talking about here. So there was just an opinion issued, and it was dealing with that issuer's jurisdiction, and it said that the state law that UCC controls. So if your UCC says Tennessee, then that controls. But that was my read, a quick read over lunch of that opinion. I'll be happy to forward it to you.
Is DTC located in New York?
Yes.
Okay. And do we have any decisions that address the question of the situs of personal property of the nature that we're talking about? Because before a court could enter an order affecting anyone's rights in property, real or personal, the court has to have jurisdiction of the property. That's easy when it's real property because it's in Tennessee or it's somewhere else. But here we're dealing with intangible property rights.
Yes.
Are you aware of any authorities that deal with that issue?
This issue, you're getting to what's the nature of a securities entitlement, and is that considered property enough to give situs to the state of Tennessee? Those issues have not been explored yet, that I'm aware of.
All right. Thank you, Mr. Chairman.
Thank you. And just to clarify, before 1994, much didn't change in 94. It just had them doing what they was doing prior to 94. Is that correct?
Yes, I would say that the practice, they were basically papering the practice that they were also using these securities. But once it was implemented in all 50 states, what I'm pointing to is that's when there was the dramatic escalation in the use of the pooled securities underpinning the derivatives complex. So they were coincident. You know, it was being used quietly, but then once it was solidly legal for them to do this, it was done on a epic scale.
And if I understand you right, if this bill goes into law, it would protect the individual investors.
Also, very importantly, institutional investors.
Okay.
This is, in terms of real asset protection, this is an enormous issue that is important for the financial services industry. So it is misleading to suggest that this is bad for business. If you provide real asset protection and you protect your financial services industry in the state, really, the other way to look at this is if the people in the financial services industry are vulnerable to the liability of this. They are being set up to be the first line of exposure to displeasure on the part of the public. So it's ultimately will be very important for the financial services industry in Tennessee and hopefully in other states to do this to provide real asset protection. And I can tell you there are people around the world that are watching this because this will be very important to them. As there are a lot of people that are now aware of this issue globally and are trying to find a solution for a safe venue.
And can you think of any particular incidents recently where this law would have came beneficial for somebody?
Where it would have been beneficial, well, I can go into where the experience we have where we see how this operates, and it was the current situation damaged people. The most important case was Lehman Brothers, the failure of Lehman Brothers. This was really the test case for this. And in this instance, institutional clients had collateral, dry powder, so to speak. They were not using this collateral. You're in the middle of a terrible financial collapse. Lehman Brothers fails, and it turns out that Lehman Brothers had encumbered the collateral of their institutional clients. These institutions did not recover access to that for over 5 years. So if you imagine you're in the middle of a crisis and you lose access to the collateral because your own custodian was using your collateral. This is what happened in Lehman Brothers is that JP Morgan was the custodian for client assets and also the secured creditor that took the client assets. And that is no longer fraud to do that. So we see people who really understand this have a real urgency to figure out a way to really achieve protection, and that would be the benefit. It's actually shockingly simple. The thing I say is just give people back their stuff. It's as simple as that. Having real direct property rights protects you from insolvency. That's why they were called securities.
Very good, and we don't have anybody else on our list, but we appreciate both of y'all for being here. Thank you. We got two more people here to testify today. Andrew Guggenheim, I think is how you pronounce that, and Timothy Amos. And if you both will have a seat there, just make sure your red light's on. Just say who you are, who you're with, and as soon as you start talking, we'll start timing, and you both will have 3 minutes each.
All right, thank you, Mr. Chairman and members of the committee. My name is Andy Guggenheim. I'm with the Securities Industry and Financial Markets Association. We are a national trade association representing broker-dealers, investment banks, and asset managers, many of whom have a presence in Tennessee. In fact, roughly 130,000 people work in the finance and insurance industry in Tennessee. There's about 1,300 securities firms and 42 broker-dealer main offices. The U.S. equity markets are incredibly efficient and resilient. Investors now have the greatest ease of access, lowest cost of trading, and best execution in history. These markets are successful in part due to the state and federal laws that work in concert to provide customers with easy access to their brokerage account as well as the ability to buy and sell securities. Article 8 of the UCC was drafted in the 1940s, updated in the 50s, 1978, and 1994. This law, which underpins securities transactions at the state level, has been adopted in all 50 states. There's also a process for amending the UCC by going through the Uniform Law Commission. I'm sure Tim will address that in just a moment. But what this law does is it helps facilitate trading and holding of securities. Among other provisions relating to the holding and transfer of investment securities, this law allows owners of securities to hold those securities either directly or either directly, that's in their own name, or indirectly, which is referred to as street name. As technology has evolved, most customers have opted to hold securities electronically with their brokers, as paper has been phased out in most industries. While holding securities in street name is the most common choice for investors, they do have alternatives for holding securities in other ways if they prefer, including physical form via stock certificate when that's available by the issuing company. But regardless of whether ownership is demonstrated via electronic certificate or on paper, a customer's property rights remain the same. Many investors find that holding securities in street names offers substantial advantages in terms of market access, efficiency, security, and cost. As a result, the majority of retail investors choose street name for their holding. Holding in street name allows investors to buy and sell securities more quickly and efficiently, resulting in lower transaction costs, greater savings, and the ability to execute trades more quickly. Customers who hold securities in street name can also take advantage of much of other services provided by their brokers if they choose, such as the ability to set a price for which to buy or sell a security, or to offer their securities as collateral for margin loans at their broker or at borrowing for banks. However, this ability is grounded in the law governing security interests and in no way diminishes a customer's ownership rights. Investors who hold securities in street name with their brokers are protected by a range of regulations dedicated to ensuring that client assets are appropriately controlled and segregated from the assets of their broker. These securities cannot be borrowed.
Mr. Amos, that's your 3 minutes, and Representative Parkinson, after Mr. Guggenheim does his, we'll take questions. Mr. Guggenheim, if you'll just identify yourself and who you're with, and I'm sorry, I got you backwards. Mr. Amos, if you'll
Thank you,
identify yourself.
Mr. Chairman, members of the committee. My name is Tim Amos. I'm an attorney here in Tennessee, and I'm one of Tennessee's 5 uniform law commissioners. And I would address a couple of things here. First off, this would create a non-uniform provision, which I think would be detrimental to the state of Tennessee. The regulation of investors and protection of investors is not exclusively the jurisdiction of Tennessee. In fact, our jurisdiction is fairly limited compared to the rights and protections that are in place by the Securities and Exchange Commission. This legislation seeks to change a couple of things that I think are very detrimental. The first, Representative Uso, goes to the issue of jurisdiction. To make this law or this change stick, basically you've taken away the contract rights to select the jurisdiction. That's the first thing that this bill does. It requires that any account held by a consumer or an investor in the state of Tennessee would be governed by Tennessee law and would not be subject to the ability to have a choice of law provision. As you would know, most securities broker dealers would choose the law of the home. That's the default that's actually in the current statute that's being taken away, because as a business, you can't run a business if you have to keep up with 50 different state laws in 50 different states, particularly in the securities industry that is nationwide. You need a uniform set of laws, and they need to stay uniform. So that's the first negative in the bill. The second negative, and I think it's a little bit incorrect, is yes, in terms of priority, the priority section in virtually all instances gives the account holder the priority. The 2 exceptions, which they are removing, which they do acknowledge. The first exception is where the consumer actively agrees to pledge his securities for a loan to buy the securities. That's called a margin account. This legislation takes away that priority and thus would effectively prevent any consumer in Tennessee from having a margin account. The second place where the statute takes away the, again, a right of a consumer is where the consumer takes and actively authorizes the securities broker dealer to lend, which they do, the securities to other folks, and for which the consumer gets a fee. So both of the exceptions in the statute that they're trying to remove are instances where the consumer has actively consented to those exceptions. Otherwise, the statute provides absolute priority for the consumer. The other point that I would make is federal law, when you provide securities and they're held by a securities intermediary, the securities intermediary has to hold 100% of those securities in an account in your name. So yes, maybe it's called an entitlement right, and maybe it's held by the DTC, which is really a trust company. It's held in trust. The consumer's account
Thank you for your testimony. We've got unlimited time for questions, and first up is Representative Parkinson.
Thank you, Mr. Chair. The DTC is well, 2 things. One, where where is it and good to see you, first of all. Right, yeah. Where is it that the consumer gives consent? In the fine print that nobody ever reads? Is that where that happens at?
Yes, it would be.
Hit your button. Yeah.
Make sure your mic, yeah.
Yes, it would be in your securities account agreement when you, I've gotten some of these, and yes, they're about 20 pages long of a lot of fine print. But yes, if you want to have your securities and you hold them in what's called street name, then yes, you would agree that the account is in your name and that your securities held in street name would be held by the DTC Trust Company. If you're a consumer and you go to the broker-dealer and you want a security, they can print you a security. Now, that comes with some downsides, meaning if you want to sell it tomorrow, you have a real problem. You have to send in the security and transfer it for next week or the week after. So most people have opted, and by consent, to have their securities held in street name because it makes it more efficient for them to manage the securities, or for that matter, for your investment advisor to manage your securities on your behalf.
And y'all are free to go back and forth.
Okay, thank you. Yeah, man, we can talk about children and everything since we're free to go back and forth, But I'm just kidding. So street name is that a term for electronically held?
Yeah, that would probably be the common parlance for what we're talking about is securities entitlement.
Okay. Thank you. That's all I need. Thank you.
Thank you. And Representative Bolzo, you're recognized.
Thank you, Mr. Chairman. Mr. Guggenheim, let me give you an opportunity to respond to some of the points that Mr. Webb and Mr. Grandy made. You likely heard Mr. Webb tell us a little while ago that for 400 years, securities were personal property. You started off some of your testimony by saying that the property rights remain the same. So those two statements strike me as being inconsistent. Can you tell us whether you agree that those two statements are inconsistent, and if so, which one is the accurate one?
Well, quite frankly, I don't think we have peace in the valley on whether this is, whether we don't really see eye to eye on this point. I think you hold the security, you hold it differently. The SEC and FINRA have put out notices about how you can hold your securities. You can hold them through street name. You can hold them through several other methods, including paper certificates. But your ownership rights remain the same. And to Mr. Amos's point about collateral, that's when your property rights change, is when you offer your securities as collateral for a margin loan.
Mr. Webb has told us, though, that the securities that many Tennessee investors believe that they own as personal property are actually being pledged by others to secure indebtedness of securities intermediaries. Do you agree or disagree with that testimony?
Disagree.
And why is that?
Because this relates to the security interest for a margin loan. So I would look at this as the way you look at collateral for any other loan. This is when you use your securities as collateral. That's when your property rights change. Now,
Mr. Amos, you mentioned something about margin accounts, and that, as I understand it, this bill would flip the priority with regard to margin accounts. If this bill were enacted, how would a Tennessee investor who has a margin account be affected either adversely or positively?
Well, I think the short answer is if you had an existing account, I'm not sure how that you would unwind that. Certainly going forward, this would not permit you to create a margin account unless there were a lender out there who was willing to lend against your securities without taking the securities as collateral. Maybe they could take some other collateral like your house or some other personal property, but they certainly, under this bill, would not be able to use the securities themselves as the collateral for that loan.
Thank you, Mr. Chairman. Thank you.
Thank you. And Representative Parkinson, you're next.
Thank you, Mr. Chair. And I just want to follow up on with Mr. Goop. I'm about to jack your name up. So let me try to get this right. Mr. Guggenheim.
That's you.
I was about to call you Google and Heim, but my question to you is this: so are the brokers not using the purchased assets as collateral?
It would only apply in the case of a margin loan where the broker has that security interest and then can use that. That's what this provision was designed for in the UCC. But in terms of just taking a security and using it without the, for a margin loan, then, or without that context, that's not my understanding.
Can you say that so a fifth grader can understand it, so I can understand it, if you don't mind? So are they? I'm just want to be clear. Are they using the purchased assets as collateral, or are they not using it as collateral?
So if I had change in my pocket, I wouldn't know the exact quarters. I would know that I own this many quarters in my pocket, but whether that, so kind of getting it down to that level of which security it is, you own securities, you own, the number that says on your brokerage statement, whether it's this security, but you still hold those same voting rights for your ownership stake in those securities, but securities, are more fungible in that respect.
So I think I'm a little clear now. So I think you are, and I don't want to speak for you, but I just want to regurgitate what I think I'm hearing. Yeah. So given the fact that these securities are in a pool, they are using the securities in the pool as collateral, but you don't know necessarily if they're using yours or somebody else's.
That's my understanding. Yes.
That's how a fifth grader would understand it. Right, you're speaking bank to me, and I need you to speak.
I only have a kindergartner or a first grade, so we haven't gotten to fifth grade yet.
But so there is then a great possibility that they could be using your assets as collateral in whatever business they're doing. Nobody knows if it's yours or if it's someone else's, but somebody's is being used as collateral. With the brokers then, correct?
I guess I would go back to you have the ownership stake, on the basis of those securities, and that's kind of the plumbing of the financial system that kind of allows for the benefits of easy access to trading and having a kind of a very liquid market.
Okay, thank you.
Thank you, and I don't have anyone else on my list, so without objection, we'll go back in session. We appreciate y'all being here today. Thank you.
Thank you.
That brings us back to the sponsor. Chairman Halsey, you're recognized.
Thank you, Chairman. Thank you, committee. At the end of the day, this bill just does two things. If you're going to have to sue to get your money back, whether it's in a pool, a big pool, a small pool, or any pool, and they've used your money as collateral on a loan, and now the big bank wants to pull it in, this bill just says, instead of the bank being at the top of the priority list of getting your money, you go to the top of the list. The second thing it does is if you have to sue to get your money back, you're going to be able to do it in the state of Tennessee instead of the state of Rhode Island, New York. Now, that's about it. Now, at the end of the day, you got to decide how much risk Tennessee people are up against. And if passing this bill will help protect them, then I think that's what you ought to do. And I think you ought to wait till Gino Bolso gets back if he's going to vote for it. If he ain't going to vote for it, then just leave him out there. That's all.
Representative Parkinson, you're recognized.
Thank you, Mr. Chair. Mr. Chair, was there an amendment on this bill?
They was, and it was traveling with us, so it's already on there.
Oh, okay. Can I get a roll call vote on this bill?
I don't have a problem with the roll call vote, so.
Okay. Thank you. We hadn't voted.
Thank you. So.
By the way,
ask for a roll call vote.
One other point, if I can make it. Mr. Webb, you've seen him before. He wrote the book, The Great Taking, that you've probably heard a great deal about. And I just want to say publicly thank you for making a trip from Sweden to be here. So.
Thank you. And not seeing any other names on my list, members, we're fixing to vote. And Madam Clerk, take the vote.
Representatives Bolso, Capley, Eldridge? Eldridge, yes? I'm sorry. Farmer? Yes. Farmer, yes. Grills?
Yes.
Grills, yes. Lamberth? Lamberth, no. Parkinson?
Yes.
Parkinson, yes. Todd? Aye. Todd, yes. Chairman Russell?
Aye.
Chairman Russell, aye. Chairman, you have 6 ayes and 1 no.
All right, the ayes prevail. House Bill 2806, civil full. And Mr. Sponsor, thank you for standing up for the little man.
Thank you, Chairman and Committee, and thanks for working with me. I appreciate it.